Miss Rodriguez, are you there?
Yes.
All right, we're ready to proceed on your file. I'll call your record. I'll call your file. It's docket 22-01270. People of the State of Michigan versus Martiano Rodriguez. This is a show cause hearing set for today. My understanding, you're being show cause for failure to pay fines and failure to submit to an alcohol safety education program, which was supposed to be completed by November 8th. How have you proceeded on both of those assignments in regards to the fines and costs and the alcohol highway safety program?
So I didn't have the funds to do either of them, but I can start on Friday as far as paying you, and then depending on what I have to pay to you, I can set up the highway class.
So you're saying, so this is, just so I've got this correctly, you pled in June 27th, you were sentenced on August 8th. It's now November 21st, and you have not even set up the alcohol highway safety education program. I can understand not having the funds to pay the court because you can do that over the course of probation in this matter.
Right.
She's not on probation. You're not on probation, so you've been given.
So I mean, because it's $100. I mean, it's just not easy to just give $100 or give anything for that matter. You know, I mean, I will, like I said, I will on Friday, I will set it up if I'm able to make a payment plan, with you guys.
Well, I'm not, we can make a payment plan you can make a payment plan with us. I mean, what's the outstanding debt?
Like almost 1,500.
Say it again.
$1,446.63.
So you have an outstanding debt of $1,446.66, and then you also have the alcohol highway safety education program.
Yes.
So why don't we do this in increments?
Okay.
In my opinion, the alcohol highway safety education program should be paramount.
Okay.
Okay. So how soon can you get enrolled in that program?
So I have to have the $100 in order to do that. And I get paid on Friday, so I can set it up on Friday.
All right. So let's do this. I don't want to give you a time frame that
Thank you.
that you're unable to. So let's do it by December 1st. Can you set up by December 1st to be enrolled in that program?
Yes.
All right. Enrollment in that program.
Okay.
Then I'm going to have you, since you have such a large outstanding debt, how long does it take to finish that program? Yeah, how long does it take to finish that?
It's a one-day program.
It's a one-day program. So if you're enrolled in that program, you should be able to finish that program by January 1st, I would imagine.
Okay.
So let's do this. Let's do this then. And so we're just going to set up a plan for you, and then we're going to see how you do on the plan. All right.
All right. Thank you.
All right. So let's have you pay by January 1st of 2022, 2023.
Yes.
$100 towards your fines and costs.
Okay. Definitely.
That'll be December. So it'll be December 1st. You enroll in that program. You get that program done. And by January 1st, you pay $100 in fines and costs.
Okay,
right.
thank you.
Now, you'll still have an outstanding debt of $1,400, around $1,400. And so if you're able to make those payments, my suggestion is if once you complete your enrollment in your highway safety education, which is most important since this is an OWI, and then start your payments for the fines and costs, why don't we come back here? Give me a date to come back. January 17th at 1:30.
Okay,
And we'll figure out a plan for the rest of the debt, okay?
all right. Thank you so much.
Yeah, what we'll do is either we'll set up a plan or we'll figure out a collection, something that'll work. But these two milestones, let's get that started on the way down, okay?
Okay, you got it.
All right, so be back here January 17th at 1:30. Your enrollment date for the program should be done by December 1st, 2022, and $100 cost should be made by January 1st, 2022. All right, ma'am?
All right, thank you so much.
All right. Do you have any questions for me?
I do not.
All right, that's all
right.
for the record, docket 2201-270. We'll see you again on the 17th, okay?
Thanks again.
All right. So let's see what happens. So we're on the record in docket 22-02034. People of the state of Michigan versus Randy Cobb. Will the parties please introduce themselves for the record?
Aaron Robinson, Assistant Public Defender for Mr. Cobb.
And sir, you are Randy Cobb?
Yes, sir.
All right, and you can hear me all right, Mr. Cobb?
This is a little low, but yeah, I can.
All right. You tell me if you can't hear me, and we'll have the volume increased or I'll speak up. All right.
That's fine, Your Honor. Thank you.
All right. This is the time set for a sentencing in this matter. And Ms. Robinson, you've received the pre-sentence report from Mr. Cobb?
I have.
And any additions, deletions, or corrections?
Not at this time.
And you've had the opportunity to go through the pre-sentence report with your client?
I did.
All right. Allocution?
Yes, Your Honor. We would be asking for time served in this matter. It appears that Mr. Cobb has about 64 days credit since being in custody. He has completed programs through CATS, such as the anger management program, as well as a coping skills program. He understands that, and he apologizes for what he did in this case. However, having such a long time in, he wishes to just have this case resolved and go on with his life. So we would request that he receive a time served sentence of 64 days, Your Honor.
All right. Is he incarcerated on anything else besides this file?
No, just this case.
Okay. Mr. Cobb, is there anything you'd like to say to the court before the court passes sentence?
Yes, Your Honor. If I may, I'd like to apologize to my wife. I never meant to hurt her. I know when I slapped her hand, I hurt her in two ways. I hurt her emotionally and I hurt her physically, and I apologize for that. I apologize also for not listening to her and putting her feelings on the back burner in our relationship. And I also apologize for being controlling. I never wanted her to fall. She had an addiction, and I took it upon myself to try to control the situation. And sometimes I realize now that sometimes you just got to let them fall. And I do apologize for everything that I've ever done to her.
All right. Thank you, Mr. Cobb. Mr. Wisty, is there a victim in the case here?
Yes, there is. I just spoke to Miss Singletary. She intends to get back on Zoom shortly here.
All right. So let's place this case in adjournment until we can get a statement from Miss Singletary on the record. Okay. All right, Mr. Cobb, I've got your statement. The complaint. Oh, she's here now. So let's go ahead. And Matt. Oh. See when she tells me when she connects. Okay. All right, ma'am, are you Abigail Singletary?
Yes.
All right. And my understanding is that you'd like to make a statement in regards to the sentencing for Mr. Cobb.
Yes, I've had to change my phone number 3 times despite the no contact order.
If I may, Your Honor. So what Miss Singletary just informed me, and she had been in contact with their office this morning, it looks like, is that where there were continued contacts with her by Mr. Cobb from the jail, basically from the date of the plea. I would turn it over to Ms. Singletary to elaborate with any questions the court has. Based on these no contact violations, I would request rather than the court follow the recommendation of time served, sentencing Mr. Cobb to maximum 93 days under the statute.
Ms. Singletary, any comment? The recommendation today is a recommendation for 64 days time served. The prosecutor's recommendation in regards to this sentence is the maximum sentence because of the no contact order violations that have occurred. I guess I'd like to hear from you, Ms. Singletary, what you think about the recommendation, and then what that's the most I can do is the maximum penalty in order to alleviate of any no contact concerns.
I'll leave you alone.
What do you think, Ms. Singletary?
I, to be honest with you, don't care either way. I just want him to leave me alone.
All right. All right, Ms. Robinson, based on,
Terrifies me.
all right, now, Ms. Singletary, you're indicating that because you have not been left alone at this point.
Correct.
Okay,
Your Honor, may I ask a few questions?
you may.
Ms. Singletary, since Mr. Cobb has been in jail, when did he first start contacting you?
I can actually pull my phone log up right now and tell you the exact date of the first call that I got that I did not answer, which was 9/27 of 22.
How frequently were the calls following that?
I've got 9/27, 9/27, 9/29, 9/29, 9/29. It's just back to back to back to back to back.
Can I make a statement?
You can after she's done talking, sir.
Did you have to do anything to stop these calls from coming in?
I changed my number 3 times and I have not heard from him since October 1st. October 1st was the last time I actually spoke with Mr. Cobb.
And at this, you're assuming after that date, he no longer knew what your number was?
Correct, because I changed it.
Like, no further questions.
All right. Anything else, Ms. Singletary?
Nope.
All right, Mr. Cobb, any statements you want to make before the court passes the sentence?
Yes, is there any way that you might be able to access my e-messages here at the jail? Because I was contacted by a Sherry Rose and given those numbers to talk to my kids.
Okay.
In fact,
I don't
when she
have any-
changed her number, I did not have it. It was in those messages from a Sherry Rose, and to find out that it was her.
Mr. Cobb, okay, so today's just a sentencing, okay? It's not, you're
Yes,
not on
ma'am.
trial for new offenses.
I know that
okay?
our
So-
relationship is over. I do understand that. She strung me along, and I just want to
All
be
right.
a father to my kids. I just want to get my life back in order.
All right. Well, in regards to.
And to be honest, the last time she actually contacted me was October 31st.
Okay, Mr. Cobb.
She
I'm gonna
contacted
pass
me.
sentence.
Mr. Cobb, just
Cobb,
stop talking.
I'm gonna pass sentence now, okay? This is a volatile situation, obviously. Children are
Leave her
involved.
alone.
You have another court to figure that out. But I'm gonna take the recommendation of the prosecutor in this case. That you spend 93 days in jail with credit for 64 days previously served, which means that you've got roughly 22 days left. That is the clearest way to me that I can protect a no contact order, because you shouldn't be contacting her while you're in jail. I'm going to waive fines and costs in this matter. I do have a $50 crime victims' right fee and a $75 state minimum cost fee for a total of, there's a $90 assessment. What's that? All right. So for a grand total of $215, and that'll be referred to collections. That'll be referred to collections. So the sentence of the court is 93 days in jail with credit for 64 days served and $215 to refer to collections. So Mr. Cobb, once you're able to get out of jail on this sentence, you are to report or at least contact the collections agency to set up a payment plan in this regard. Is there anything else for the record in docket 22-02034, Mr. Wisty?
No, Your Honor.
Anything, Ms. Robinson?
And that takes care of the PA 53 as well then?
Yeah, both PA 53 will be dismissed as a part of the sentencing, the full sentence.
Okay, thank you. Nope, nothing further.
Some of that is pursuant to the victim indicating that they just didn't want to be contacted. And so the full sentence in this regard is the full jail time sentence. Any questions, Ms. Singletary? All right. That's all for the record in docket 22-02034. Thank you, everybody, for their appearance. Mr. Hannah, on Mr. Beck, the public defender who was just assigned today, but she says that there have been some overlapping matters from circuit court probation. So why don't you get with her and see if there's if any type of disclosure between circuit court and district court would suffice so that we don't have to set it for hearing again, because that the plan was, well, let's just set it for hearing again because she just got involved, but we've been here twice before. Let's see. And Mr. Wisty, you can be, if you want, you can be involved on this. You don't know anything about the case, so, but let's see if we can work it out rather than set it for another hearing. Okay. All right.
Just so I understand, it will basically be dismissed for the time being if it doesn't get worked out.
We'll most likely have a hearing if it doesn't get worked out. Okay. So that Mr. Hannah's here, we might as well just have a hearing.
Mr. Robinson.
And Miss Robin, this is Miss Robinson right here. All right.
Working it out now, Your Honor.
All right. Mr. Raleigh, are you ready on Mr. Hodges?
Yes, we're ready, Your Honor.
All right. So we're on the record in docket 22-00537. People of the State of Michigan versus Brent Hodges. Will the parties please introduce themselves for the record?
Jake Westy on behalf of the people.
Jacob Raleigh on behalf of Mr. Hodges.
And sir, you are Brent Edward Hodges?
Sir.
All right. This is the time set for sentencing. Just quickly, Mr. Wisty, is there any restitution in this case?
No, Your Honor.
All right. There's been a pre-sentence report done for this matter. Mr. Raleigh, have you had the opportunity to go over the pre-sentence report with Mr. Hodges?
I have, Your Honor.
Any deletions, any additions, deletions, or corrections?
We have none, Your Honor.
All right. Allocution, please.
Thank you, Your Honor. As noted in the pre-sentence report, Mr. Hodges has had struggles with substance use. However, he is about to go into federal custody for 46 months. He tells me his report date is January 1st. With that in mind, I would ask that the court simply sentence him to time served or perhaps concurrent with federal custody, whatever might be appropriate. But I don't think supervision is appropriate in this case.
So the start date on the federal sentence is January 1st?
Yes, sir.
Okay. And then and Mr. Hodges is not incarcerated at this time?
That is correct. He's under pretrial supervision or
Federal bond.
yes.
Under federal bond? Okay,
So I already drop already.
Yes.
right. And that's out of the Eastern District of Michigan, correct?
Yes.
Okay. Mr. Hodges, anything you'd like to say to the court before the court passes sentence?
No, just they had took 1471 from me because they thought I was selling the pills, but I would take it. I take it, and they seized my money, so I was just asking, could I get my $1,400 back?
All right. I'm uncertain what the status is of that. Maybe Mr. Raleigh or Mr. Wisty can help you once the case is disposed of. That's evidence until the case is disposed of. What is the sentence in federal court? What is that? What's the underlying federal charge that you're being sentenced, that you're receiving sentence?
Conspiracy to deliver,
Okay.
manufacture 56 grams.
All right. So it'll be the sentence of this court on count 1, which is a guilty plea of use of controlled substance, based on the representations made and the probation report. I'll follow the recommendation of the probation department pre-sentence report. So follow the to judgment of sentence, I will sentence you to 1 day, which was previously served. I will not sentence you to any further incarceration based on the 46-month Department of Corrections assignment from federal court. I'm gonna, pursuant to JOS, I'm gonna waive all fines and costs. I cannot waive the crime victim's right fee of $75 and the state minimum courts fee of $50 for a total of $125. However, because of your status of 47 months, I'm going to administratively close the file, which was also at the request of the pre-sentence report, understanding that it would be hard to make those payments when you're in federal custody, of course. And that's all for the sentence. I'm no probation, no rehabilitation. You're really in the federal system now, as you know. Okay. Anything in regards to the court sentence, Mr. Raleigh?
No, Your Honor.
Okay. Mr. Hodges, good luck to you, okay? All right. That's all for the record, docket 22-00537.
Thank you, Your Honor.
can't do it. You did. Where's the mute?
We're on the record in docket 22-01381. That's Brittany Weaver and Travis Winters versus Brittany Lucero. And if I remember correctly, Kayla Barrow is no longer a defendant.
I have that if you need that.
Oh, no, I'm good.
Okay.
I'm good with that. So I would have Mr. Winters and Miss Lucero so that I'm able to see them. Miss Lucero? Harris. All right. So you're Brittany Harris?
No, Brittany Weaver.
Okay, but is it Brittany Harris now?
Sarah.
Okay, all right. All right.
I thought that was the email address.
So let's go on the record in the case. Will the parties please identify themselves for the record? Go ahead, Ms. Weaver.
I'm Brittany Weaver.
All right. And sir, you are Travis Winters?
Yes, Your Honor.
All right. And ma'am, you are Brittany Lucero?
Yes, Your Honor.
All right. This time set for a hearing, we put this afternoon set for a hearing today. And the hearing is set for the allegations by Ms. Weaver and Mr. Winters. You filed the suit.
Yes, sir.
And so what I'm going to do is based on everybody's appearance today, we'll have a hearing, and if there's any indication that well, we'll just take it as it comes. But I guess I'd like a little bit of so my understanding of the case and how we got here, and then we'll move forward. I'll hear from Ms. Weaver, so you can give a brief opening statement, an opening summation, and then have Ms. Lucero counter that, and then we'll start taking proofs. But I guess my first question is, this is initially stems from a small claims case?
Yes, Your Honor.
All right. And then it was moved to district court because it was initially it was found to be an intentional tort.
Correct.
All right. So what is the request you're asking of this court today?
Because we got a default judgment on July 8th. I would like either my property back or the judgment amount that we were awarded. So that's what the discovery hearing was for Brittany to produce where she is working, that kind of stuff, so I can start the garnishment if she's not going to return the property.
All right. So really, this really comes out of a default judgment. And when was the default judgment entered?
On July 8th, 2022, and the amount was $6,584.96.
Wow.
On August 1st, in order to seize property, a subpoena filed for discovery hearing was scheduled for September 26th at 8:30. Both myself and Mr. Winters appeared. Ms. Lucero did not. On September 11th, the defendant was personally served by a process server at her home in Benton, Arkansas. And I do have proof of that and a statement from the process server stating they personally served her.
So you're, for today, and not unlike a true debtor's exam, you would like the opportunity to ask her some questions under oath in regards to collecting on the $6,584 default judgment.
Yes, sir.
Okay. Miss Lucero, any response to what you've heard so far?
Yeah, my response is the fact that these were gifts to my children, like clothing, Christmas presents from last year, everything, and they want that back. That's Indian. I'm sorry, but that's not good. It's not correct, because that's taking away things that they gave to the kids for Christmas.
Well, that would make sense if we were having a hearing on those facts, but the default judgment ends the hearing on those facts. So really, it's just a collections issue now. The fail to appear after being served means that there's been a default entered, and therefore it's just a matter of collection. in regards to what Ms. Weaver's trying to do, which is collect on the 6,584 judgment.
Yeah, but that's
Now,
what I'm,
if you want to set aside the judgment, that's another thing, but you may have run out of time on that.
I was not notified. On August 1st, we had a custody case when they did that. July 8th, I was
Okay,
not.
but this isn't the custody case. This isn't the custody. This has nothing to do with the
Claim.
custody case. This has to do with the small claims district court case.
But how, okay, this is why I can't make no one understand, is that how can they collect things that they do not owe that is in my name?
Well, they can collect it when they say it's theirs and then you don't appear and they get a default judgment.
I was not notified on any of that.
I have you as personally served on September 11th.
No, he came on exactly 2 weeks after my kids came home on September 9th. He came and like the end of September.
All right, so I have you personally served.
And then if you look at the text message, she admits to, why are you having people come to my house to serve me? And Travis goes, because it's your Michigan paperwork.
And it's
So
just,
I do have you personally served and then a failed to appear, which is what's required. Required is before you file a lawsuit, you're required to personally serve the person. And
Yes.
then so that's how you got the default judgment.
but what I'm saying is that they did not serve me until after. Till after. you
After
guys,
September 26th?
yeah, after.
No, that was September 11th.
Because September 11th, I was at work.
I'm sorry, August 11th, because he returned the children on August 9th.
He returned the kids on September 9th at 4 p.m.
And you
So I have you served on September 10th.
From where
September
though?
or August.
I was at work.
At 807 Northeast Benton, Arkansas, 72015.
That was after. It was not September 10th because September 10th was a Saturday.
I do also, but I have as part of the process that she's a white female with blonde hair.
She has a roommate, we have found out.
I don't have
Her name is Nicole. Her name is Nicole.
Oh my
But
God.
did you serve her roommate or did you serve her?
No, the process server had no idea. That's the statement I got from the process server. But if you look at the text message that Brittany sent Travis, it states that, why are you sending people to my house? And he said, it's your Michigan court papers.
We're gonna go back. Because I did not get served. I got served by a man. And it was a Zoom paperwork. That's all it was. Just a Zoom paperwork with your Tony Flores with your name on it.
And that was the guy that served her.
And that was
So you indicate you were served on that day.
I was not served on that day. It was 2 weeks after my kids came home, and it was September 20th when he served me.
And the other stuff was served by mail, by certified mail.
It was September 20th when he served you?
29th. It was an older man that came to my house at 6 p.m.
Well, I know you weren't here for the September 26th date, and I know you were failed to appear on the June 22nd date.
I didn't know we had, what was June 22nd?
That was, it looked like your district court case, that it looked like that's when it came from small claims to district court.
It was actually, I think that was actually mailed to her.
I didn't
because that's how I got it.
All you got in the mail was Amazon crap.
Yeah, I got Amazon stuff.
Right here. This is the one we got from.
All right, well, I'll tell you what we're gonna do is we're gonna go ahead and just have a hearing on this, all right? As a part of the hearing, I'll allow, but I don't know. I would assume that Miss Weaver came today in regards to the default judgment. I'm gonna have these marked as I don't see a date on this one though.
You want me to see if I can find it and circle it for you?
Yeah, on this one, I don't see a date on the first
go
one.
here?
Yeah. So Nathaniel, go. So I'll take any evidence in regard to this, but I don't see I see the email, but I don't see a date on the first page.
Something right here. At 12:30 or 20:30. Says 9:10. I might have a better picture of it on my phone.
So your representation, Ms. Lucero, today is that you were not served on September 10th at 10:30.
Yes, that is correct. I have all the text messages right here in my hand where it sits there and says that he was trying to contact the kids September 10th on a Saturday when he was not supposed to contact kids on September 10th. Then right here, I have it right here in my hand about September 9th when I picked up the children at 4 p.m. Arkansas time. Where,
but ma'am, your text messages mean nothing to me.
But I have every single evidence. He never been served by a woman or only by a man, and it was at 6:30 p.m. at my home.
Well, I guess the one way to find this out is to get this individual to zoom this in.
He's in Arkansas.
Well, he can zoom.
Okay.
We can zoom him in.
All right.
So let's set this. And what I need for you to do is I need for Mr. I can't tell his name here.
Winters, or are you talking the process server?
Yeah, Charles Kesey.
Okay.
Kesey. I need Charles Kesey here so we can walk through this and he can explain how he served her prior to, because if he served her on September 10th, she obviously has notice of the date. Although I want to make sure.
I have my phone off, or I might be able to get a better picture of it.
Yeah, I'm not going to see it in here getting played. And I will show.
Where does it say in the process that she was served on a date for to be on here on September 26th? Because I know she's served, I just don't know what date she was given.
Yes, that one, I was told I could email that. That was a receipt from the post office.
Yeah, so let's get him here.
Okay.
Let's get Mr. Kesey here. Because Ms. Lucero, if you're indicating that you did not receive proper service, then we'll just go to hearing on the allegations that you owe this money. If we set it for hearing and Mr. Kesey indicates that he did serve you and you had notice of the September 26th date, then you are defaulted and we really just have a collections issue. Does that make sense to you, Ms. Lucero?
Yes.
All right. I think that's the easiest way and to decide what we're here on. Now, if you're unable to get Mr. Kesey's Zoom presence, because that's how we'll take that.
Okay.
Then we'll just proceed as if this is a brand new hearing, and I'll hear any allegations, and then I'll hear anything from Ms. Lucero. What I want it to be known is that when we have the next hearing, because we're going to set it again, is that everybody needs to treat this like you're bringing in evidence, okay? Such as you did, ma'am, Ms. Winters. And Ms. Lucero, your iPhone won't do. You have to send me whatever is in that contests these charges in regards to, any issues or anything of those concerns that you want me to review as to why you would not owe $6,584. That's the alleged debt here. Does that make sense to you, Ms. Lucero?
Yeah, it does.
And make sure you know that this is different from your custody case.
Yeah,
you have an ongoing custody case, and this is a claim that arrives out of small claims into district court.
Yes, I understand that. My lawyer down here contacted you guys up there about the issue. Not-
All I got was every circuit court document filed in the custody hearing. That's what I got. And I don't find that helpful in trying to determine whether you owe the amount or not. I will grant you that out of Judge Koenig's court, there was a transfer of a custody case. And that is ongoing. And I understand that those are issues that will be resolved by an Arkansas court. I'm simply trying to determine if the $6,584 that's alleged to be owed, A, has been defaulted on, and B, if it's not been defaulted on, is it a valid allegation that you owe the money? And I will take any evidence in regard to that. But right now, I think I got a process of service problem. I need to make sure that you had notification of the September 26th date, because if you didn't, then I can't grant the order for collections. And then we're right back to where we started, which is a hearing on whether you actually owe $6,584. Does that make sense?
Yes, I understand that. That's why I'm trying to figure out myself. How do I owe that much 6,000 some odd money when they don't even purchase any of my stuff? It's mine, which I can show that to
I
you.
don't know. Miss Winters, I don't know. I mean, Miss Lucero, I don't know. They have to prove that they have to prove that you owe them the money. They have to prove by preponderance of the evidence that you owe them the money. They can't just say you owe me money. They have to come here with evidence and show me that you owe them over $6,500. And then I will listen to you, and then I'll make a ruling.
Yes, that's what I'm trying to say. Is that does she have evidence about it? Because that's what I don't.
We're going to find out. We're going to find out at the next hearing. But here's the problem. We don't get to there if you were served. If you were served and you defaulted, we never get to the factual allegations of the matter. And that's what I'm trying to determine, if you were actually served, and if you were served appropriately, which means that you were given notice of the September 26th date in Arkansas, that's where the problem lies. Because if you weren't given notice, then they have to prove their case. If you were given notice, then they just have a collections issue.
Your Honor?
Yes.
I have a question. So the court case was filed on February 9th. She was served on 4/20. On 6/7, we had mediation, which she appeared. On 6/22, we had court in front of Judge Milmore.
That was the small claims.
That was the small claims. And then Brittany had 10 days to respond to that. Milmore sent her the information, which I have it, because I didn't have to serve her for that. And I was told that after them 10 days is when I could get the default judgment if she didn't respond.
No, I didn't.
It must have come out of there. It must have come out of small, because I had my first hearing on it on September 26th, and that's when she failed to appear.
And that was the discovery hearing.
Yeah, and that was the fail to appear.
Correct.
Yeah. So that is the fail to appear for my purposes.
Okay.
I can look into Judge Milmore's 10-day notice, but with her living in Arkansas, it creates problems, as you know.
Correct.
But what would really help me determine that proper service is Mr. Charles Kesey to come and testify by Zoom that at the next date that we give you, that he did give process, and he gave it on the 26th date, because then we'll have a record that this is really a collections matter, and then and then we'll go from there. Okay. So let me give.
I found out that paperwork was filed, correspondence. I was never served with that. I found out about that this morning.
Okay.
So I was never properly served with her responses.
All right. I don't think I have her responses. All I have
Pictures?
I have almost every.
Yeah, that's what I have.
Yeah, I have
got that
almost
today.
every motion filed in circuit court concerning the custody matter, which is fine, except this isn't a custody matter.
Correct.
You know, this is to see if you can prove what she owes you, the $6,500. So let's get a new date for Mr.
None of our stuff.
Kersey's appearance.
Okay.
So we can figure out are we in a collections realm or are we in actually a fact-finding realm?
December 6th at
Yeah.
2.
So
September-
we'll set it for
Sorry, John.
December 6th.
Can't do December 6th. We're gonna be in Arkansas. We have custody case on December 5th, and then Travis has a domestic violence case on December 6th in Arkansas.
All right, well, so you're still litigating all the
Yes,
custody
the
matters.
custody case is on December 5th.
Well, at this point, you set it when you're able to, because,
It'll be January.
yeah,
Okay.
yeah, because they're working out bigger issues on this case.
Yes, sir.
You weren't served on September the 10th.
I know it wasn't. My car got repoed that day.
Now, something else, and I told him take
So
it.
it is, okay, so I'm gonna have you stop talking so we can get a date for the courtroom.
January 23rd at 2.
January 23rd at 2:00 will be the date for the continuation of this hearing. Now that we know that this is either a collections issue or it's an issue to see if you can recoup what you lost, so you have to come and prove it. But the first thing I'll need is to, under oath by Zoom, talk to Mr. Kesey so he can explain some of the paperwork of the canine processing services. Because right now, Ms. Lucero is indicating she didn't get service, and if she wasn't served, then we are back to a formal hearing and not a default collections issue. I'm going to give you back your paperwork, but I'm going to make a copy for the court file, okay? Ms. Lucero, do you have any questions on this? I just want to make sure you're properly served at this point.
No, I understand. And that's why I was going to ask you, when you're properly served, don't you have a document saying that you got served?
And I have the document saying that you got served. So now I'm going to call the individual to testify as to the document because I'm having trouble reading the document.
Okay. Yeah, because
Right.
I was assigned something when you get served.
Right. And if you provide a email to my staff, I will email you a copy of the process server so that you can question the process server at the next hearing, okay?
Okay.
Because I know your allegation is that I understand your allegation is that you weren't served, so we don't have a default judgment.
Mm-hmm.
All right. Anything else, Ms. Weaver? And my staff will give you a copy of this. The date is January 23rd at 2 p.m. All right, ma'am?
Yes, I got it.
Okay. All right. Anything else, Ms. Lucero?
Mm-hmm.
Is that a yes or a no, or
What was that? Sorry.
Anything else?
is
Oh,
there
no.
is there anything else, Ms. Lucero?
No. Sorry.
All right. No, it's all right. Just make sure you provide an email address so we can provide you with some of the paperwork concerning the process server's testimony, okay?
Okay.
All right. That's all for the record in docket 22-01381. We'll see everybody on January 23rd.
You have all the evidence in that file.
I have photos.
I'm talking the stuff that was originally sent to her in January or February, I'm sorry.
You know, I may have it. I'll
I
have,
have photos and
through it.
receipts.
but
and-
whatever you think I need to be considered, make sure you have a copy to give me.
Okay.
Because at this point, most of this file is just the custody
No,
file.
she
Okay,
keeps saying that.
right. So, all right,
Thank you, sir.
thank you. There's that, and that's the process.